This video is about Quo Warranto, and that is your Rule 66 of the Rules of Court. So this is our outline. We are going to distinguish Quo Warranto under the Rules of Court from Quo Warranto under the Election Code. When can the government commence an action against individuals or associations, and when can an individual file an action for Quo Warranto? What is the judgment in Quo Warranto action? What are the rights of a person if he is a judge entitled to public office, and the limitations? Also is the case of the Sereno, Chief Justice Sereno. So this is going to be the flow of our discussion, and again, this is in accordance with the syllabus issued by the Supreme Court. Preliminaries muna tayo. So what is Quo Warranto? That is a Latin term. Literal meaning is by what warrant, or what is your authority. So your Quo Warranto, it is a remedy. It is a remedy if you want to dispute the title to a public office, or if you want to dispute the franchise or privilege that we all know that belongs to the state. Your Quo Warranto, therefore, it is a demand by the state. Demand by the state upon who? Demand by the state upon the individual to show by what right you hold the office, or it is a demand by the state upon a corporation to show what right do you exercise some franchise or privilege. Because again, we all know that the franchise or privilege are franchises or privileges or grants or authority coming from the state. General rule, therefore, your Quo Warranto proceeding is commenced by the government, and the government is the proper party plaintiff. That is the general rule. And again, it is an extraordinary remedy. It is a prerogative writ, and as such should be administered cautiously and in accordance with certain well-defined principles. So we're going to distinguish now Quo Warranto under the Rules of Court and Quo Warranto under the Election Code. So the applicable article is Section 253 under BP bilang 881. That is your Election Code of the Philippines. So again, the applicable law is BP bilang 881. So what are the things that you need to remember about Section 253? Your Section 253 says that any voter can contest the election of regional, provincial, or city officer on the ground of ineligibility or disloyalty to the Republic of the Philippines, and she should file a sworn petition for Quo Warranto with the Commission within 10 days. 10 days from when? 10 days from the proclamation of the results of the election. So what are the things that you need to remember about Section 253? Again, this is your Quo Warranto in electoral proceedings, that your petition can be filed by any voter, and the petitioner or the voter can file it depende kung sino ang may jurisdiction. COMELEC if it is a regional, provincial, or city officer, and RTC if it is a municipal officer, and MTC if it is a barangay officer. When are you going to file your petition? Within 10 days. 10 days from when? 10 days from proclamation of results. And what is the ground? The ground is ineligibility or disloyalty to the Republic of the Philippines. Example dyan is yung citizenship. Usual na example sa political law is the citizenship or the person running is a permanent resident of another country. So who can file an action for Quo Warranto under the Election Code? Answer is any voter. How about the Quo Warranto under the Rules of Court? It could be the government through the Solicitor General or the SOLGEN, the public prosecutor, or individual. Pag individual, merong qualification. That is very clear according to your Section 2 and Section 5 of the Rules of Court. Where are you going to file your Quo Warranto under the Election Code? In MTC or RTC, depende sa posisyon. So if it is a barangay officer, MTC. If it is a municipal officer, RTC. And in the COMELEC, if who is involved is a regional, provincial, or city officer. HRET, that is your House of Representatives Electoral Tribunal, and the Senate Electoral Tribunal if that concerns the senators or the congressman. And in the Supreme Court, but the Supreme Court here would be acting as Presidential Electoral Tribunal if it concerns the president or the vice president. That is according to our 1987 Constitution. How about for your quo warranto under the rules of court? Where are you going to file? Sino ang may jurisdiction? Take note that if it is the Solicitor General who commences an action for quo warranto, there are three choices. First is it can be filed in the RTC, but RTC where? RTC in the city of Manila. So that is very specific. RTC in the city of Manila, in the Court of Appeals, or in the Supreme Court. Only pag si Solgen ang magko-commence ng action. Otherwise, in the Supreme Court, in the Court of Appeals, or RTC, where the respondent or any of the respondent resides. But in all of this, you have to remember again the doctrine of hierarchy of courts. Hindi pwedeng dumiretso sa Supreme Court unless you have that reason. You have to go to the lowest first. So you start first with the RTC and then you go up. This is in accordance with Section 7 of your Rule 66. When are you going to file? You are going to file within 10 days. 10 days from when? 10 days from proclamation. So this is a post-proclamation remedy. That is a post-proclamation remedy under the Election Code. How about the quo warranto under Rule 66? You are going to file it within 1 year. 1 year from when? 1 year from the cause of such ouster or from the right of the petitioner to hold such office or position arose. That is according to your Section 11 of Rule 66. Dati, si Section 11 ay hindi masyadong pinapansin, but because of the case against Chief Justice Sereno, naging controversial na si Section 11. What are the grounds? Again, ineligibility and disloyalty to the Republic of the Philippines. How about the grounds under the rules of court? Very clear in your Section 1 of Rule 66, you can file your quo warranto against any person, and that person is intruding or unlawfully holding or exercising a public office, position, or franchise. You can file also your action for quo warranto against a public officer. That public officer is suffering an act which by the provision of the law constitutes a ground for the forfeiture of his office, and you can file it also against any association. We call this in the corporation law as a de facto corporation because that corporation is acting as a corporation but it has no authority, lawful authority, or it has not been legally incorporated. Take note also that your Rule 66 does not apply to persons who usurp an office in a private corporation. Bakit? Because Rule 66 is not applicable because in that case, the applicable law is RA 8799. So for controversies in the election or appointment of directors, trustees, officers, or managers of corporations, partnerships, or associations, applicable law is Republic Act number 8799, and you will be commencing and trying it in the RTC, which has jurisdiction over the principal office of the corporation, partnership, or association concerned. So for application, let's read this 2001 bar exam question. There was this group of businessmen. They formed an association in Cebu City and they called themselves Cars Company. They want to distribute and sell cars in Cebu. It did not incorporate itself under the law, nor did it have any government permit or license to conduct its business as such. So the Solgen filed a case before the Regional Trial Court in Manila, questioning and seeking to stop the operations of Cars Company. The latter filed a motion to dismiss. The ground is improper venue, claiming that the main office and operations are in Cebu City and not in Manila. Is the contention of Cars Company correct? Why? What did we say? You can file a quo warranto that is under Rule 66 if there is an association that is acting as a corporation but they have not been legally incorporated, or they don't have that lawful authority to act. So that is like a de facto corporation. So therefore, the Solgen is correct in filing a petition for quo warranto. But what did we say? If it is the Solgen who commences an action for quo warranto, the Solgen can file it in the RTC where? RTC in the City of Manila, in the Court of Appeals, or in the Supreme Court. But you have to observe the hierarchy of courts, or the doctrine of the hierarchy of courts. So what did the Solgen do here? The Solgen filed a case, and he filed the case in the Regional Trial Court in Manila. Therefore, the contention of Cars Company is not correct. So see ha, this is a 5% question. Remedial law ito, but answerable only by a provision of Rule 66. Hindi mo kailangan ng jurisprudence, just apply the provision of Rule 66. Okay, so ulitin natin, who can file an action for quo warranto, who may commence? Answer is the government, that is through the Solgen, Solicitor General, or the public prosecutor, and an individual. Kailan makakapag-file ang individual? If that individual is claiming that he is entitled to the office or position that is unlawfully held or exercised by another person. So, punta na tayo sa when can the government commence an action against individuals or associations. So, take note that your quo warranto proceeding can be classified into two, and that is mandatory proceeding or the discretionary proceeding. And for the mandatory proceeding, again, brought by the government through the Solgen or a public prosecutor, and kailan siya nagiging mandatory? When directed by the President, or there is this complaint, or the Solgen or the public prosecutor has good reason to believe that the case for quo warranto can be established by proof. Again, there is this good reason to believe that the case can be established by proof. That is very clear according to your section 2. So that is a mandatory proceeding. Kailan naman nagiging discretionary? It is brought by the Solgen or a public prosecutor at the request or upon the relation of another person. So there is this request or relation of another person, and that another person is called the relator. So yan yung relator. And ano ang requirement ng batas? There must be leave of court or permission of the court and indemnity band. That is very clear according to your section 3 of Rule 66. Kailan naman an individual may commence an action for quo warranto? Section 5 has the answer. If you are a person and you are claiming that you are entitled to a public office or position, and that public office or position is exercised by another person, then you can bring an action for quo warranto. Ano ang sinasabi ng jurisprudence? If you are a private person suing for your quo warranto petition to be successful, you must show a clear right to the contested office. You must be able to prove that you are entitled to the controverted public office, position, or franchise. Because if you are not able to prove that one, then the holder of that office has a right to the undisturbed possession thereof. In fact, if you read your section 6, very clear si section 6 that in your petition for your quo warranto, first is you should set forth the name of the person who claims to be entitled. You should assert your right to the title or to the office or possession, and you should also include the respondent who is unlawfully in possession thereof. In actions for quo warranto to determine title to a public office, the complaint, to be sufficient in form, must show that the plaintiff or the individual is entitled to the office. Under Section 5, Rule 66 of the Rules of Court, the petitioner must assert or must aver and be able to show that he is entitled to the office in dispute. Without such averment or evidence of such right, the action may be dismissed at any stage. So take note of that. So you read Section 6 because importante yan. When the action is against a person for usurping a public office, position, or franchise, the petition shall set forth the name of the person who claims that he is the one entitled, the averment of his right or his assertment of the right to the office, the name of the respondent who is unlawfully in possession thereof, and all persons who claim to be entitled to the public office may be made parties, and the respective rights to such office determined in the same action. So diinan lang natin our discussion. Your quo warranto, again, it is a remedy. It is a remedy if you want to dispute the title to a public office. And your quo warranto proceedings are general rule commenced by the government, and your government is the proper party plaintiff. But under Section 5 of your Rule 66, an individual is allowed to commence an action for quo warranto if he claims that he is entitled to the public office that is usurped by another person. And if it is an individual instituting the quo warranto proceedings, what should he do? He should show that he is entitled to the office in dispute. Otherwise, the action may be dismissed at any stage. Also, under Section 6, Rule 66, it requires that the individual should state in his petition his right to the public office and the respondent's unlawful possession of that office or possession of that disputed position. And also, what did the court say? The suing private individual must show that he has a clear right to the contested office. If he fails to establish these rights, then it warrants the dismissal of the action for lack of cause of action. So that would be the ground, walang cause of action. In fact, the court will not even pass upon the right of the defendant because that defendant continues, because of that appointment of that defendant, he continues in the undisturbed possession of his office. So please take note of this. So let's go now to the difference between an action for quo warranto that is filed by an individual versus a quo warranto filed by a solgen or public prosecutor. So what did we say? If it is filed by an individual, that individual has the burden of proving his right to the office in dispute. Otherwise, the court shall not pass on the right of the defendant in the office. Sabi nga ng Supreme Court decisions, if it is a petition for quo warranto and there is this private individual suing, that private individual must show his clear right to the contested office. His failure to establish his right warrants the dismissal of the suit. Bakit i-dismiss? For lack of cause of action. In fact, sabi ng Supreme Court, it is not even necessary to pass upon the right of the defendant who, by virtue of his appointment, continues in the undisturbed possession of his office. So if it is a case filed by Juan de la Cruz against Mocha Oson, if Juan de la Cruz is not able to prove his right to the office, then Mocha Oson continues in the undisturbed possession of her office. The court will not even pass upon the right of Mocha Oson. How about if it is an action filed by the solgen? Ano ang sinabi natin? It is not necessary that there be a person claiming to be entitled to the office alleged to have been usurped. At kahit walang individual dyan, the court still has that duty to pass upon the right of the defendant only. So in that case, so if it is a case filed by the solgen against Mocha Oson, kahit walang individual, pwede pa ring mag-proceed, and the court has the duty to pass upon the right of Mocha Oson to hold that office. So we are going to end our discussion here kasi magiging mahaba na. I will be discussing the rest in the part 2. Thank you very much for watching and have a good day.